The House began its march towards impeachment last month based on an anonymous complaint filed with the Intelligence Community Inspector General. One America's Neil W. McCabe spoke to legal analyst Bruce Fein about whether it's legal to identify the whistleblower.
OAN legal analyst Bruce Fein told One American News it is vital to justice that Americans know the identity of the so-called whistleblower.
Anonymous, faceless accusers are the death knell of justice.
Fein, who held senior positions in President Ronald Reagan's Justice Department, said reporters have a moral obligation to learn the name and make it public.
It's obviously critical in assessing the credibility of a speaker to know what his ulterior motives might be. What is your history? Moreover, you need to see that person to assess their demeanor. They look like a liar or not. That's why it's indispensable that a so-called whistleblower or anybody else who makes an accusation, especially one as serious that could bring the presidency to an end.
The so-called whistleblower should have known there would be consequences, he said.
And as to the idea that somehow it was illegal to disclose this name, under the First Amendment, there would be a right for OAN or any other media, not an obligation, I think, to disclose the identity. Or that's what we call organized scrutiny of government, is the purpose of the press.
It is also a concern that the complaint does not have any first-hand account, he said.
We understand that there are laws that if there's retaliation, that may be a justification for some remedial redress in court. But after all, this individual cannot, it's like Harry Truman said, if you can't take the heat, stay out of the kitchen. What is also critical here is that in this particular case, the whistleblower doesn't claim to have any first-hand knowledge of anything. He's just reporting what other people told him. Maybe he misheard. Maybe they misspoke. All those things need to be examined through cross-examination and identifying who this individual is.
House Democrats now argue that because they have testimony from other sources to back up the claims made in the complaint, the whistleblower is no longer part of the process. But Fein said this violates an important principle of law.
There's something called the silver platter doctrine. Can you take something that's illicitly obtained, hand it over to somebody and try to cleanse it of the initial taint and then move forward? And the answer is no, that doesn't wash. If you can show that some evidence was tainted because of some wrongdoing earlier, there's a nexus between the two. They all go out.
Fein said President Donald Trump is still protected by the Constitution and has the right to confront his accuser.
You have a right to confront and cross-examine your accusers. Right in the Sixth Amendment. Now it'll be said that's a criminal case and this is a civil case. But that kind of distinction really doesn't wash when it comes to impeaching the President of the United States. I hear these statements, well, House is just like a grand jury. And the Senate is like, that's not true. No grand jury tries to remove a President of the United States based upon non-criminal conduct.
Neil W. McCabe, One American News, Washington.
Want to see more videos like this? Click on the link below and subscribe to One American News on YouTube, and call your cable provider and kindly demand that One American News is added to your lineup. Call and subscribe today.